Baker Botts, LLP, provides podcasts for educational purposes only. They are not legal advice and are not intended to establish an attorney-client relationship. This communication may constitute attorney advertising.
Welcome to the Lawful Influence podcast, where we pull back the curtain on legal issues in the world of campaign finance, elections, and lobbying. I'm your host, Sterling Marchand, coming to you from Washington, D.C. In this episode, we're going to discuss de-breaking election news out of Colorado. If you haven't heard, on December 19th, Colorado's Supreme Court became the first in the country to disqualify former President Donald Trump from running for office again. It did so in a 130-page decision with 3 of the 7 justices dissenting by applying the insurrection clause of the 14th Amendment that was added after the Civil War to prevent Confederate soldiers from returning to the government. The effect of the ruling would be that Trump cannot appear on Colorado's primary ballot, nor would any write-in votes be counted for him. Now, the Colorado Supreme Court has stayed its decision until January 4th, giving Trump's attorneys time to file an appeal with the U.S. Supreme Court, which they have already indicated they will do. This is an extremely unprecedented situation. The insurrection clause has only been used a handful of times in the history of the United States, but it's certainly not the last. And it's also unprecedented in terms of a major party's candidate being declared disqualified or barred from holding office. And certainly all signs at this stage point to Donald Trump being the front runner for the Republican nomination. But there's a lot to unpack with the Colorado decision, and there's going to be a lot more on this in the coming weeks. So in this episode, we're going to cover background on what the decision was, discuss a little bit about the dissent, and then focus on what's coming next. So as an initial matter, the Colorado Supreme Court was applying Section 3 of the 14th Amendment. And in relevant part, it states, "No person shall be a senator or representative in Congress or elector of president and vice president or hold any office under the United States, having previously taken an oath as an officer of the United States to support the Constitution of the United States, and who has engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof." Now, as I mentioned before, the 14th Amendment, and this clause of the 14th Amendment, was enacted following the Civil War, and it was really geared towards keeping Confederate soldiers out of the U.S. government in the period of Reconstruction. But most recently, this issue has come up again following the events of January 6, 2021, when a mob of individuals invaded the U.S. Capitol and destroyed property in the process. And as you recall, that chain of events started with a rally that was led by former President Donald Trump. And so recently, there have been a number of challenges across the country as we get closer to the 2024 election against Trump's qualification to be elected as president again. And it focuses on an argument that he is disqualified under this insurrection clause of the 14th Amendment. In states like Oregon, Maine, Colorado, New Hampshire, Minnesota, and Michigan, various groups representing electors in those states have brought these legal challenges. Now, up until the decision in Colorado on December 19th, every court that has considered these arguments have dismissed them. Back in November, the Minnesota Supreme Court dismissed an insurrection clause challenge and ruled that Trump could appear on the state's primary ballot. That court avoided dealing with any constitutional issues by finding that the state's primary was essentially a party-run contest, during which constitutional eligibility was not an issue. So the Minnesota Supreme Court left the door open to future challenges Trump appears on the general election ballot. Similarly, a Michigan Court of Claims also refused in November to disqualify Trump. In that instance, the court found that determining whether Trump had engaged in insurrection was a matter better left for Congress. Now, underpinning all of these challenges are a number of factual and legal issues. First, the court has to find Donald Trump engaged in an insurrection or rebellion. And here, that's the January 6th attack on the U.S. Capitol. From a legal perspective, the court also has to find that the 14th Amendment is what is called self-executing. And that means that it is automatically barring someone from holding office without any additional action taken by Congress. The court also has to legally find that the states can enforce it, as opposed to requiring Congress to enforce it. And multiple courts have now found that the 14th Amendment can be enforced by states, even while finding other ways to deny the insurrectionist clause challenges. So let's talk a little bit about what the decision was in the Colorado case. In that case, a split Supreme Court of 4-3 upheld a trial court's finding that former President Donald Trump did engage in the January 6th insurrection through his actions. And essentially, the Supreme Court upheld a 5-day trial that considered a wide variety of evidence from experts, as well as statements from Trump himself. But first, the Supreme Court had to find that the 14th Amendment insurrection clause applied to the President of the United States and that states could apply it. Because while the district court in Colorado found that Trump factually had engaged in insurrection, that court found that legally the 14th Amendment did not apply to the President of the United States. But the language of the 14th Amendment, as the Colorado Supreme Court picked up on, applies to any officer of the U.S. And in looking at what the drafters of the 14th Amendment meant by officer, the Colorado Supreme Court found that it did in fact apply to the President of the United States, both based on the plain language of the word officer, as well as what the drafters of the 14th Amendment would have understood at the time that it was written. The Colorado Supreme Court also found that this was an issue that could be resolved by the states. Because remember, one of the arguments against applying the 14th Amendment in this instance is that the intent is for Congress to execute this language as a disqualification. And so the Colorado Supreme Court had to find that states themselves could enforce this part of the 14th Amendment. And here they did so because none of the language in this section of the 14th Amendment commits enforcement solely to Congress, whereas in other parts of the Constitution, it is very clearly spelled out that Congress shall have responsibility for enforcing certain rights and qualifications. And so, in other words, the Supreme Court in Colorado found that this prohibition in the 14th Amendment, Section 3, is self-executing. It is enforceable on its own, absent some implementing legislation from Congress. Then the Colorado Supreme Court turned to the factual issues. And this is a really interesting and lengthy part of the opinion. But it found, walking through the evidence that the district court considered, that the January 6, 2021 attack on the Capitol was in fact an insurrection, given that it was done by a large group of armed individuals who forcibly entered the Capitol. They overran law enforcement and took physical possession of the space. The trial court and the Supreme Court in its appellate review also examined Trump's own statements in the lead up to January 6th. And they looked at his statements that he made at so-called Stop the Steal rallies, his statements on January 6th itself at a rally in front of the White House. They looked at his tweets and posts on social media, along with other conduct by him. And what they concluded was that it, quote, amply demonstrates that President Trump fully intended to and did aid or further the insurrectionists' common unlawful purpose of preventing the peaceful transfer of power in this country. And so remember that part of the issue on January 6th was that Congress was meeting to certify the results of the 2020 election. And the efforts of the insurrectionists on that day were aimed at stopping that certification process. And what the Colorado Supreme Court found was that Trump's actions supported them. And it goes on to say, quote, he exhorted them to fight to prevent the certification of the 2020 presidential election. He personally took action to try to stop the certification. And for many hours, he and his supporters succeeded in halting that process. The Colorado Supreme Court also considered and rejected an argument by Trump that his statements were protected by the First Amendment. This has been a common defense that former President Trump has made, saying that the things that he says at rallies or on social media posts should be protected as political First Amendment speech. But in applying the Brandenburg test, the Colorado Supreme Court found that Trump incited the attack on the U.S. Capitol and that it was designed to and did incite actual violence against not only the country, but against senators and representatives who were in the process of carrying out their lawful duties by certifying the election results. And the Colorado Supreme Court pointed to video footage that was broadcast that day of the insurrectionists attacking law enforcement with weapons. And in some powerful language, the Colorado Supreme Court states, quote, in conducting our independent review of the district court's factual findings, we agree that President Trump intended that his speech would result in the use of violence or lawless action on January 6th to prevent the peaceful transfer of power. Despite his knowledge of the anger that he had instigated, his calls to arms, his awareness of the threats of violence that had been made leading up to January 6th, and the obvious fact that many in the crowd were angry and armed, President Trump told his riled up supporters to walk down to the Capitol and fight. He then stood back and let the fighting happen, despite having the ability and authority to stop it, either with his words or by calling in the military, thereby confirming that this violence was what he intended, end quote. And so what this means, the conclusion of the Colorado Supreme Court's decision in finding that the 14th Amendment applies to presidents, in finding that the states can enforce the 14th Amendment, and in finding that Donald Trump had incited and participated in an insurrection, was that Trump is disqualified from holding the office of president under Section 3 of the 14th Amendment. And that as a result of that, it would be wrongful, it would be unlawful for the Colorado Secretary of State to list him as a candidate. Now, the Colorado Supreme Court clearly recognizes that this is unprecedented. And they state, quote, we do not reach these conclusions lightly. We are mindful of the magnitude and weight of the questions now before us. We are likewise mindful of our solemn duty to apply the law without fear or favor and without being swayed by public reaction to the decisions that the law mandates we reach. End quote. And in that final effort, the Colorado Supreme Court determined that the only appropriate remedy, given all of these conclusions, is that Trump's name cannot appear on the primary ballot, and that votes, even write-in votes for Donald Trump, cannot be counted in the state. Now, as I mentioned at the outset, there were 3 judges who each wrote a separate dissent. And the first was by the chief judge, Wright, who dissented on the grounds that the state election law did not provide the proper adjudicative process for determining whether a candidate engaged in insurrection under the 14th Amendment. What the dissent really boils down to is a due process or a procedural objection. And the chief judge's issue is that the state election law provides certain expedited review for certain types of challenges. And that was the procedure used here. And so it meant that a lot of the normal timing and discovery that would go into a civil case was expedited and truncated in an effort to get to a decision more quickly. Even though the district court engaged in a 5-day trial, heard evidence, heard from experts, Chief Judge Boatwright dissented to the use of those expedited procedures in this particular question of presidential qualification, which he argued was complex. But he also acknowledged at the same time that other qualifications in the U.S. Constitution, whether someone is 35 years old, for example, or whether someone has held 2 terms, he recognized that that would be appropriate for these expedited procedures, given that they present less complex issues of fact. Justice Samore also dissented on due process grounds, arguing that the 14th Amendment does not state what procedures must be followed to make the determination under Section 3, nor does it provide the burden of proof for evidentiary rules. Justice Samore also argued that Section 3 is not self-executing, that it requires enacting legislation by Congress to enforce it. And so he rejects the conclusion by the majority that states are free to enact their own legislation to enforce the disqualification of candidates. Justice Samore noted that Trump has not been charged with a criminal charge of insurrection, which would have afforded Trump a full panoply of constitutional rights that are afforded to all criminal defendants. And finally, the dissent does a lengthy historical analysis of the passage of the 14th Amendment and a number of cases immediately applying Section 3 in the aftermath of the Civil War. But importantly, he distinguishes those qualifications for office under Section 3 from other qualifications for president under the Constitution. The last dissent was penned by Justice Birkenkotter, and he dissented that Colorado's election code authorizes state courts to decide whether a presidential primary candidate is disqualified under the 14th Amendment. And in another lengthy analysis, he essentially finds that the Colorado state election law was not intended to broadly grant authority to Colorado state courts to cover federal law and questions on whether an insurrection disqualifies candidates. So that's the Colorado Supreme Court decision and the dissents in a nutshell. And just briefly, as we wrap up, I want to cover the next steps. The Colorado Supreme Court recognized that this was going to be appealed, and so it stayed its decision. So the immediate impact is very little. The decision is stayed through January 4th, giving Trump's attorneys time to file a petition with the Supreme Court of the United States challenging the decision. And if the order remains stayed, which the U.S. Supreme Court can and probably will do, then come January 5th, the Colorado Secretary of State has to certify the contents of the ballot, and Trump will likely be on it. But the bigger question is whether Trump is actually disqualified from holding office. Is a finding under Colorado state law by the Colorado state courts that Trump is disqualified going to stick? And if other states find that Trump is disqualified, what does that mean for the presidential election? Now, as I noted, it is all but certain that the Colorado decision will be not just appealed to the Supreme Court, but that the Supreme Court will take it up. Other states are very close to making decisions as well. Maine has a case regarding the same challenge to Trump's candidacy that is expected to act within the next week. And so what we're facing is the U.S. Supreme Court will likely have one, if not two or more cases before it early next year. The Supreme Court has never ruled on application of the insurrection clause. And so there's very little to go on. But with the Colorado decision specifically, there will be a number of issues they could consider. They could take up the factual findings that Trump was found to have engaged in insurrection. They could take up the legal finding that Section 3 of the 14th Amendment is self-executing. They could take up the legal finding that states can enforce Section 3 of the 14th Amendment. Any one of those findings would have broader implications beyond just the Colorado Supreme Court's decision. But if they decide to pursue a more narrow path, they could solely take up the question of whether or not Colorado's state election law, in this particular case, was the right avenue for considering application of the 14th Amendment. But again, that would have a much more limited application moving forward, which might be beneficial to some of the Supreme Court justices. But with other states concurrently considering the same claims, it seems unlikely that they will limit their analysis to such a narrow ruling. I think it's a bit of an understatement, but there's obviously a risk that any decision by the U.S. Supreme Court in the next year is going to be viewed as political and divisive. Chief Justice Roberts is very aware of the hyper-partisan environment that the country is currently in. But if the court only addresses the legal issues, it could result in a situation where Trump is factually found to have engaged in an insurrection, but still legally qualified to remain on the ballot. So it's a very bizarre time that we're living in, given the state of affairs of politics. We have a party's major candidate facing challenges as to the qualification under the 14th Amendment and is being accused of having participated in an insurrection. Now, these aren't the only types of cases that Trump is facing that arise out of the attack on the Capitol on January 6th. The criminal charges brought by special counsel Jack Smith charged Trump with conspiracy to obstruct an official proceeding, conspiracy to defraud the U.S. government, and conspiracy against threats. That criminal trial is expected in D.C. courts sometime early next year and could likewise impact Trump's ability to appear on ballots. There will be a lot more on this in the coming weeks, and we'll continue to follow it as the petitions for cert get filed with the Supreme Court. And as the Supreme Court starts to make decisions about hearing this argument, we'll keep you updated in what is not only breaking news, but an emerging area of law that is going to have some immediate and real implications for the 2024 presidential election. Thanks for joining me today as we covered the breaking news out of Colorado. I hope you found it helpful and informative. Until next time, I'm Sterling Marchand.
Thank you for listening to this Baker Botts podcast. Baker Botts has the experience, knowledge, and people to address our clients' most significant legal issues. For more information on Baker Botts practices, please visit us at bakerbotts.com. This presentation is provided by Baker Botts, LLP, for educational and informational purposes only. It is not legal advice and is not intended to establish an attorney-client relationship. Under the rules of certain jurisdictions, this communication may constitute attorney advertising.